Thank you.
Mr. Geiser, assuming, as did Justice Gorsuch, that I believe the government can intervene and can dismiss, to dismiss, because I think that's a form of proceeding with the action. You can take discovery, you can make a motion for summary judgment, you can do all sorts of things, including moving to dismiss. So assume I do that. Doesn't the good cause standard for intervention provide you with the standard? Meaning, if you have to prove good cause to intervene, you have to prove you have a reason. And the reason just can't be arbitrary and capricious. Isn't that the question that simple? And isn't that the question that would happen in, it's all one motion, as it was in this case. It was one hearing. The government came in, said, we want to intervene because we think we have to dismiss now. The court held a hearing, listened to its reasons, and said, they're rational. They're not arbitrary and capricious. So isn't that the standard? Well, are they arbitrary and capricious?
Yeah, I don't mean to quibble with the premise, but just to be complete about it. I think Your Honor said that part of proceeding with the action is moving to dismiss. And of course, under C3,
I accept that you don't think it is, but assume okay. I do.
I do think the good cause standard provides an extra layer of protection for the relator, and that the government should, as a part of the good cause showing, explain why it didn't intervene earlier.
I don't disagree with you, but that goes to the issue of whether the choice they're making now is arbitrary and capricious.
I think it does, Your Honor. I think that is another layer of protection for the relator.
How do you see arbitrary and capricious as different from the rational relationship test of the 9th and 10th Circuit, or between that and Rule 41, where it says a court has to consider whether a dismissal is proper?
Well, I think that it is similar to the 9th and 10th Circuit standards. I think it's very different than the Rule 41 standard, where the court is considering
similar,
whether—
but how different?
Well, I think very different. Rule 41 is looking to prejudice to the defendant.
Putting that aside, because it's a plaintiff's motion, and I agree with you, it's what's proper for the dismissal of the action, but assume that I think proper has a meaning. What meaning would you give it?
If we are stuck with the Rule 41 standard, I think proper still would have to be something that is not arbitrary, because something that's arbitrary is improper, and not irrational, because something that's irrational is also not
irrational
proper.
Is different than capricious. Not arbitrary or capricious is different than rational.
I think that could be true, Your Honor, and we'd be fine with either standard. I think in this case we could prevail under either standard if it's applied in a meaningful way.
Okay.